They said it was about safety. They said 10 rounds were enough. For years, those words were repeated like gospel, a comforting promise that if the state just limited what you could own, the violence would stop. But behind every promise was a threat. And in California, that threat became law. It started quietly. A few legislators claimed no one needed a magazine that held more than 10 rounds. It sounded reasonable to those who had never held one, a minor restriction, a compromise, a common-sense reform. But every gun owner in California knew what it really meant. Once the government decides how much protection you're allowed, it won't stop at 10. It didn't. And before we dive deeper, like and subscribe to our channel, because understanding your gun rights starts with staying informed. In 2000, California banned the sale, purchase, or import of magazines that held more than 10 rounds. Overnight, the state that once defined the frontier became the testing ground for one of the most restrictive gun laws in the country. Yet even then, there was an illusion of tolerance. People could still keep what they already owned. It wasn't a crime to possess. Not yet. But as the years passed, the climate changed. Each tragedy became a pretext. Each election cycle brought new pledges to do something. By 2016, Proposition 63 changed everything. Possession itself became illegal. Millions of otherwise law-abiding citizens suddenly faced a choice no American should ever have to make: surrender your property, destroy it, or risk becoming a felon. Families hid what they legally bought years earlier. Gun owners who had done everything right were now treated like criminals. And yet, through the fear and confusion, one simple question echoed across the state. If these magazines are so dangerous, why do police still use them? The answer, of course, was simple: because they work. Because they're standard. Because they save lives. But Sacramento didn't want to hear that. The debate was no longer about safety. It was about control. For years, courts looked the other way. Lower judges applied the old balancing tests, deciding that if the government claimed public safety, restrictions were automatically justified. Few believed any federal court, especially not in the Ninth Circuit, would ever side with gun owners. Then came 2019. Judge Roger Benitez, a federal judge in San Diego, read the Constitution and saw something the state had ignored. The Second Amendment wasn't written to protect what politicians prefer. It protects what the people use. He struck down California's magazine ban as unconstitutional. His opinion was unapologetic, methodical, and bold. Limiting magazines in common use, he wrote, violates the core of the Second Amendment. For one extraordinary week, California glimpsed freedom again. Gun shops reopened their shelves. Online retailers scrambled to keep up. Thousands of packages crossed the state line. It was later called Freedom Week. 7 days when Californians were treated like citizens instead of suspects. Estimates suggest over 1 million magazines entered the state in that short window. And something remarkable happened. The sky didn't fall. There was no surge in crime, no chaos. Just ordinary people reclaiming what the rest of America already owned. But the celebration was short-lived. Because in California, freedom never goes unchallenged. Within days, the state appealed. The Ninth Circuit stayed Benitez's ruling, freezing the victory while lawyers prepared for a drawn-out war. 4 years, the case, Duncan versus Bonta, wound through the courts, suspended in legal limbo. Meanwhile, other states watched closely. If California's ban could fall, their own laws might crumble next. The state's lawyers argued that magazine limits were a reasonable regulation. They claimed 10 rounds were enough for self-defense, that anything more was excessive. But their logic relied on an old legal framework, one that the Supreme Court was about to erase. In June 2022, everything changed. The Supreme Court issued its landmark decision in New York State Rifle and Pistol Association versus Bruin. The justices dismantled the balancing tests that had justified decades of gun restrictions. From now on, courts could no longer weigh public safety against constitutional rights. The new rule was simple. If a gun law isn't rooted in text, history, or tradition, it fails. No more excuses. No more speculative benefits. No more bureaucratic morality plays. The court reminded the nation that rights aren't negotiable privileges. They are guarantees, and the burden of proof lies with the government, not the citizen. Suddenly, the ground shifted under California's feet. Every gun restriction built on public safety arguments began to wobble. and Duncan versus Bonta was waiting. Armed with Bruin, the plaintiffs returned to the Ninth Circuit. This time, the judges could not hide behind balancing tests. The text of the Second Amendment was clear. The historical record was clear. There was no tradition of limiting how many rounds a citizen could keep in a firearm. The question was no longer about preference, it was about survival. The state tried to argue that high-capacity magazines were unusual. But statistics told another story. Millions were in circulation nationwide. Standard equipment for America's most common firearms. Glock 17s, AR-15s, and countless modern pistols. When the court looked at the numbers, the argument collapsed. Magazines holding more than 10 rounds weren't rare. They were ordinary. And in a stunning decision, even the Ninth Circuit, long considered hostile to gun rights, struck down California's ban. For the first time in decades, a major federal appellate court recognized that the Second Amendment protects magazines in common use for lawful purposes. It wasn't just a victory for the plaintiffs, it was a seismic shift for the entire nation. Because if even this court could not justify California's restrictions, the writing was on the wall for similar laws from coast to coast. Politicians like to talk in numbers. Crime rates, magazine counts, statistics. But the courtroom debate misses something vital. The human element. Imagine waking in the dead of night to the sound of your door being kicked in .4 intruders. Adrenaline flooding your body. You grab your firearm, the same one the state says should hold no more than 10 rounds. In Houston, that exact scenario played out. A man defended his home against 4 armed attackers. He fired more than 10 rounds. He survived because he didn't have to reload under fire. If he had been bound by California standard, those 2 seconds needed to reload could have been fatal. That case isn't theory. It's proof that magazine limits don't save lives. They cost them. Even police acknowledge the math. Officers carry pistols with 15 to 17 rounds and keep spare magazines on their belts. Why? Because under stress, accuracy plummets. Even trained shooters miss most of their shots in real confrontations. If the state truly believed 10 rounds were enough, why doesn't it hold its own officers to the same standard? Because deep down, everyone knows the truth. When your life is on the line, you don't count rounds. You fight until the threat is over. Duncan versus Bonta was more than a legal argument. It exposed the divide between those who trust citizens and those who fear them. The state's position was built on distrust, that ordinary people can't be trusted with the same tools as law enforcement. But the Constitution was written on the opposite assumption, that freedom begins with the presumption of responsibility. The founders didn't carve out exceptions for good intentions. They understood that once the government starts deciding how much liberty you can handle, liberty itself ceases to exist. But the state wasn't finished. The ink on the decision was barely dry before lawmakers regrouped. If they couldn't ban magazines outright, they would find another way. Suddenly, new bills flooded the legislature. Proposals to designate vast, sensitive places where carrying a firearm would be banned, sometimes entire city blocks. Others required gun owners to buy liability insurance before they could legally carry. Paperwork expanded. Training requirements doubled. Fees increased. It was a strategy of exhaustion, what many called death by 1,000 cuts. They knew their bans wouldn't survive the Bruin test. But by layering new rules, they could drain the time, money, and patience of ordinary citizens until exercising a right felt like a crime in itself. Yet even this strategy had a weakness. History. There is no historical tradition of forcing citizens to purchase insurance to own a gun. No precedent for declaring entire towns sensitive places. Each new restriction only invited more lawsuits. And one by one, those lawsuits began to pile up. As California fought to salvage its laws, other states began to feel the tremors. New York, New Jersey, Hawaii, Illinois. All had their own magazine limits built on the same legal foundation that Duncan had just demolished. In New York, plaintiffs invoked Duncan directly, arguing that under the Bruin standard, the state's 10-round cap had no historical basis. New Jersey's ban faced the same fate, its justification unraveling line by line. Even Hawaii, within the Ninth Circuit's jurisdiction, stood in Duncan's shadow. If California's ban couldn't survive, how could Hawaii's? Precedent spreads like a contagion. One victory forces others to confront the same question. And the more courts that strike down these bans, the harder it becomes for any to stand. That's how revolutions begin. quietly, case by case, until the entire structure collapses. And that's where part one of this story pauses. At the edge of a new frontier. California's war on magazines has triggered something larger than the state ever imagined. A national reckoning over how far the government can go in the name of safety, and how much the people are willing to concede before they say enough. When Judge Benitez's ruling dropped again in 2023, it was more than a decision. It was a spark. Across California, gun owners who had been silent for years finally felt seen. For decades, they'd lived under layers of regulation, registrations, waiting periods, bans, fees, approvals, background checks for ammo, each one sold as common sense, yet none delivering the promised peace. Now, one federal judge had said what many had whispered for years. You can't legislate away evil. You can only disarm the innocent. And once those words were written into law, they couldn't be unseen. The ruling sent shockwaves through Sacramento. Attorney General Rob Bonta called it dangerous and reckless. Governor Gavin Newsom labeled it a direct threat to public safety. But for millions of Californians, it felt like justice. For once, the Constitution had spoken louder than politics. Yet even as the ink dried, the state moved fast to block implementation. Appeals were filed, stays requested, and the gears of government turned to stall the inevitable. Behind the scenes, emails circulated between advocacy groups and lawmakers. How to mitigate the ruling, how to control the narrative, how to ensure that law enforcement messaging leads the news cycle. They couldn't stop the ruling, but they could slow it down, delay compliance, drag the case back through the Ninth Circuit, and pray that time itself would dull public outrage. It was strategy through fatigue. If they couldn't win, they'd wait. Meanwhile, the Duncan decision didn't stay contained. Tea became a weapon, cited in courtrooms across the country. In Illinois, attorneys invoked Duncan in their challenge to the state's new Protect Illinois Communities Act, which banned rifles and magazines in one sweeping stroke. In Colorado, plaintiffs referenced it to argue that the state's local magazine bans violated the same Bruin-based reasoning. Even in Washington state, long a model for gun control advocates, the same pattern emerged. Courts began demanding proof, not promises. History, not hypotheticals. And every time a state failed to provide a 1790s-era analog for their modern bans, another pillar of the gun control edifice cracked. One case after another, the walls began to crumble. It's easy to picture these legal battles as abstract. Lawyers, paperwork, distant courtrooms. But behind each case were real people. Veterans, mothers, small business owners, retired police officers. They weren't extremists. They weren't radicals. They were citizens, people who followed the law, paid their taxes, and watched their rights erode inch by inch. One plaintiff, a retired Marine, had used standard 30-round magazines his entire adult life, the same kind issued to every service member who fought overseas. When he came home, those same magazines turned him into a criminal. His statement to the court was simple: "If I was trusted with these in Fallujah, I should be trusted with them in Fresno." That single line carried more truth than 100 legislative hearings. Because the debate was never about rounds. It was about trust. The trust between government and governed, between the Constitution and the citizen. And for too long, that trust had been broken. Gun control advocates often claim that magazine bans save lives. But when pressed for proof, their data crumbles. The Rand Corporation, hardly a pro-gun organization, found no conclusive evidence that magazine restrictions reduce violent crime. The Department of Justice's own research on the 1994 federal assault weapons ban reached the same conclusion. The law had no measurable effect on crime rates. So what do these laws actually achieve? They turn law-abiding citizens into easy targets. They give criminals an advantage, because criminals don't obey magazine limits, background checks, or registration laws. And they give politicians a talking point, a way to stand at podiums and claim they did something, even if that something made no one safer. The numbers don't lie. But the headlines often do. By late 2024, the fight had taken on national gravity. With multiple circuits issuing conflicting rulings, the question was no longer if the Supreme Court would step in, but when. If the court grants review, the stakes couldn't be higher. Because a single decision could do for magazine bans what Bruin did for carry permits, erase decades of restrictions overnight. It could set a binding precedent nationwide, that the Second Amendment protects arms in common use, regardless of how many rounds they hold. That ruling would not only invalidate California's law but also dismantle similar bans in New York, New Jersey, Maryland, Massachusetts, and more. It would redraw the legal map of the United States, a restoration of rights unseen in modern times. But the opponents know it too. And they're preparing for the fight of their lives. As lawsuits multiplied, so did the messaging war. Mainstream networks began framing the court victories as dangerous expansions of gun rights. Editorials warned of an America flooded with high-capacity weapons. But few mentioned that these magazines were already in the hands of millions of lawful owners. Few mentioned that, during Freedom Week, not one of those millions committed a crime with their newly purchased magazines. That silence wasn't accidental, it was strategic. The same organizations that preach, follow the science, suddenly dismissed data when it didn't fit the agenda. Their goal wasn't to inform, it was to instill fear. Because fear motivates votes, and votes sustain power. Every new restriction wasn't just about guns. It was about control, political, cultural, and psychological. Once the people accept that their safety depends on surrendering freedom, freedom is already gone. Yet, from the ashes of frustration, something new began to rise. Gun rights organizations, once fractured by infighting and bureaucracy, started to unite. Independent activists, attorneys, and local gun shops pooled resources. Crowdfunding campaigns funded lawsuits. Grassroots networks tracked new bills before they even reached committee. Ordinary gun owners began to understand the legal process, not as observers, but as participants. They learned the names of judges, memorized legal precedents, followed filings, and showed up in courtrooms. It was no longer just about owning guns. It was about defending a principle, that rights, once surrendered, are never returned willingly. And this time, they weren't fighting alone. Across social media, channels and creators amplified their voices. Journalists, lawyers, veterans, and citizens turning the digital world into a modern town square for constitutional debate. The establishment controlled the airwaves, but the people controlled the conversation. By 2025, California's legal war on magazines had evolved into something far bigger. A symbol of how states test the limits of federal authority. It was no longer just a courtroom battle, it was a philosophical one. How much can a government restrict in the name of safety before it ceases to be free? How far can lawmakers reinterpret the Constitution before it becomes meaningless ink? Every new bill, every new restriction was a line drawn on that battlefield. And yet, for all their power, the state's enforcers face a problem they cannot legislate away. Resistance rooted in conviction. A population that understands its rights is the most dangerous force to tyranny. Because once people remember what they were given, they refuse to forget. As 2025 unfolds, whispers grow louder that the Supreme Court will take a new challenge. One that could strike down all magazine bans nationwide. The petition argues that if the Second Amendment protects arms in common use, then the case is already closed. Tens of millions of standard capacity magazines exist across the United States, used daily for sport, defense, and training. If those are unusual, then so is the very concept of freedom. A decision could come as early as 2026, and when it does, it won't just decide California's fate. It will decide whether states can treat constitutional rights like privileges to be rationed. Because the court's answer to Duncan versus Bonta will echo far beyond one state line, will echo through history. Legal battles aren't cheap. Every filing, every expert witness, every appeal costs time and money. But every dollar spent is an investment. Not just in one case, but in the preservation of every American's right to self-defense. That's what lawmakers often forget. These aren't faceless organizations fighting for abstract ideas, they're citizens funding their own defense against the very government that's supposed to protect them. Every lawsuit filed is a declaration that freedom still matters. And every win, no matter how small, chips away at the idea that bureaucrats know better than the Constitution. America now stands at a crossroads between two visions. One believes rights are permanent, fixed by the words and intent of the founders. The other believes rights are flexible, privileges to be managed by experts and updated by emotion. The outcome of this debate will define the next century of American liberty. Because once one right becomes negotiable, the rest will follow. If the government can decide what size magazine you need, what stops it from deciding what kind of speech you need, or what kind of faith you need? Freedom doesn't vanish all at once, it erodes. One law, one justification, one good intention at a time. And unless someone draws the line, there will be nothing left to defend. That's why this fight matters. Because it's not just about 10 rounds, it's about the principle that the government does not grant freedom, it recognizes it.
The Second Amendment isn't negotiable, it's not a suggestion, it's a warning to those who would rule rather than serve. And as long as courts, citizens, and creators keep shining light on these battles, freedom still has a chance. So, stay informed. Support the organizations fighting in court. Share the facts, not the fear. Because the moment you stop paying attention, they win by silence. You've been watching the Firearms Legal Desk, where the Constitution still has a voice. The next case on the docket could redefine every gun law in the nation. Don't look away now. Stay ready, stay aware, and remember, freedom defended once is freedom earned twice. Subscribe to our channel and be first to know when the next ruling drops.